Hello, Pod A students. Welcome to part 2 of the criminal justice system. So where we left off, we were talking about the arrest. A crime has been committed. There has been a gathering of evidence. There's now been an arrest of a suspect. We've talked about the Fifth Amendment and due process rights. So now that suspect is processed by law enforcement. So they've been arrested, they've been booked, they give their name, their date of birth, other personal information. They're informed of the charges against them. They'll be stated more formally later on in the courtroom, but they're usually at that point fingerprinted and photographed and searched. They might even be asked to stand in a police lineup if there's witnesses that need to view them. Personal property is taken away, and they are awaiting the next stage of the criminal justice process, which is pretrial. So the initial court appearance, the Sixth Amendment requires that criminal prosecutions move forward quickly. Okay, remember, a public and speedy trial. So within 48 hours of arrest, suspects have the opportunity to appear in court. At this time, they appear before a judge and are reminded of their rights and the charges that are being brought against them. They're also reminded at that point of their Sixth Amendment right to an attorney. If they can't afford one, they would be appointed a public defender after that time. The judge also decides at that point whether or not the defendant should be released from custody and what are the conditions for release. So one way that the defendant could be released is through the posting of bail. So bail is included in the Eighth Amendment protections. It would be money that the defendant would pay to the court as a guarantee that they will come back for their next court appearance. The amount would be determined by the judge on a case-by-case basis. Really depends on the severity of the crime. And once bail is posted, the defendant would be released from jail until their next court appearance. The judge could also at that point determine not to set bail. This would be in extreme circumstances if the person was deemed a flight risk, like they're not going to return for trial, or if they thought that that person might be a danger to others. Typically at the initial pretrial hearing, the defendants, like facing a misdemeanor charge, are required to enter a plea of guilty or not guilty. If it's a felony case, typically they will have another later court appearance. So a preliminary hearing then would need to be held. This would be the next step in most felony cases, would be this preliminary hearing. And the purpose of this is to determine whether there's enough evidence to take a case to trial. So the prosecutor has to prove that there's probable cause that a crime was committed and that this suspect that they're naming is the one that committed it. In some states, the courts would also allow a cross-examination of witnesses by a defense attorney, but preliminary hearings typically are very short or brief because the main goal is to determine if there's enough evidence to justify a trial. In some felony cases, there would be a grand jury that takes the place of a preliminary hearing. And a grand jury is a type of jury that's weighing evidence to determine if there's going to be a further trial. A grand jury is not determining guilt. They are only determining if there's enough information and evidence that a trial is necessary. Typically, the juries are much bigger. They're serving for a set period of time. They also don't hear both sides of a case. They're only hearing the prosecution's version of the events. Jurors need to consider the question, did a crime take place and did this defendant commit it? If they believe that the answer to both parts of that question is yes, then they hand down what is called an indictment. An indictment is a formal accusation against that suspect, and then that means that there is going to be a trial. The next step in the process is if there's enough evidence, assuming there's enough evidence to go to trial, the next step would be an arraignment. An arraignment is a court appearance in which the suspect has to enter a plea of either not guilty or guilty. If the plea is guilty, the judge just moves ahead and sets a sentencing date. There is no need for a trial because the suspect is saying that they are guilty. It saves the time and money of a full trial. If the plea is not guilty, then the judge is going to set a trial date for later on. Prosecution and defense will have time to get their cases together, and then a trial would begin. Before an arraignment, a defendant could set up a plea bargain. Plea bargain is an agreement in which the defendant pleads guilty in exchange for a lighter sentence. This happens very, very frequently. Plea bargains still typically result in jail time, but a lot of times defendants choose this option to avoid a longer sentence or to spare themselves the time and expense of a trial. We have seen recently 94% of state-level felony convictions, are the result of plea bargains. So it's happening very, very frequently where the prosecution, the state government, or the state prosecutor tries to negotiate a plea bargain with the accused in order to avoid the cost and time of a trial. There are pros and cons to this. The critics of plea bargaining argue that sometimes it lets dangerous criminals get out of jail too soon, or that it allows the government to pressure innocent people into pleading guilty for fear of a heavy sentence if they lose in court. However, government prosecutors, often as supporters, say that plea bargaining really helps the court system from having too many cases and overburdening the state prosecutors and public defenders. So let's assume that there is going to be a trial. If that was to continue, if there was no plea bargain, if the accused or the suspect pleads not guilty, then the case would be going to trial. So remember, kind of a review of the Sixth Amendment, that is the suspect's constitutional rights for a fair and impartial trial. The idea is that there are several factors that need to be considered in order deciding whether a trial has been speedy or not. So what is the length of the delay? What is a prosecutor's reason for a delay? What's the defendant's view of a delay? And then what is any potential harm to the defendant caused by the delay? In federal cases, Congress has actually set a limit of 100 days after an arrest for a federal case to be brought to trial. If the time limit isn't met, that case might be dismissed. But oftentimes defendants might waive that right. It gives the attorneys more time to prepare or accommodate the needs of witnesses. So sometimes it's in the best interest of the accused to have more time. As far as the public part of the Sixth Amendment is concerned, it was a very important component to the framers creating the Sixth Amendment. They believed it was important to keep the trial public, to make sure there was fair judgment of the defendant, and they also believed that society would benefit from seeing justice served. But sometimes there is conflict between our rights. So sometimes the right to a free press and free media and media coverage might conflict with our right to a fair trial. If that media coverage and public knowledge of the intimate details of a case might conflict with the ability of that defendant to have a fair trial, they might be asked that the public is not allowed into that courtroom. If it helps protect the accused in some way, maybe or maybe the victim even, if the victim is a minor, or it's a delicate circumstance where maybe it would be to the best interest of the parties involved that the media is not included in the courtroom. You might have some changes to that public part of the trial. So bringing us to a jury, the other part of the Sixth Amendment mandates that the jury be impartial or unbiased and made up of members of the local community. We already talked about in Chapter 15 how typically a typical jury is about 12 jurors who must reach a unanimous verdict in order for a case to be decided. The Supreme Court has made some decisions in previous precedents that it can be less than 12 jurors necessary in that jury trial. The most important component of this, though, a jury trial, is that the jurors are impartial, that the way that the potential jurors are chosen is fair and unbiased. So during a process called voir dire, the lawyers and judge in a case question potential jurors to determine whether there's any reason to disqualify them. A lawyer could challenge a juror, maybe if there's a specific reason, or they might challenge, let's say, the example that your book talks about is if a juror on a murder case if that person is opposed to the death penalty, they might disqualify that juror if it's a death penalty case, something to that effect. Lawyers can also include jurors through something called a preemptory challenge. This is something that's given without reason. So typically each lawyer would have the opportunity to have a limited number of preemptory challenges where they really don't have to give a reason for discluding a juror. Typically in the past, this has been used to demonstrate bias in race or cases of race or gender, so that part would not be allowed. But preemptory challenges are still allowed as long as they are not strictly based on a particular bias. So going on with that Sixth Amendment still, the right to an adequate defense, there's a very important Supreme Court precedent, a case called Gideon versus Wainwright, where an individual accused of a crime was not provided with an attorney when that is one of their constitutional rights. So remember that defendants have to have access to legal counsel. The Supreme Court has said that all criminal suspects in all states have the right to a free court-appointed lawyer if they can't afford to hire a lawyer on their own. So this is a Supreme Court precedent that you're going to want to remember. The right applies even when a police investigation is no longer a general inquiry into an unsolved crime, but has begun to focus on a particular suspect. Then that opportunity for a lawyer needs to be present. As far as presenting evidence in a criminal case, the burden of proof in a trial rests with the prosecution. It is the prosecution's job, the government's job, because they are the prosecutors, to prove beyond any reasonable doubt that a defendant is guilty. The prosecutors will present both direct and circumstantial evidence to make their case in a trial. But in general, the evidence needs to satisfy two different rules in order to be admissible in court. It needs to be relevant and it needs to be competent, meaning that that evidence that they are presenting needs to meet certain standards of reliability. The testimony of a very young child, for example, might not be considered competent because they might not be a very reliable witness. But ultimately, the judge in a case has the final say on whether or not evidence will be admissible. So going on in that process are jury deliberations. Again, in order to reach a guilty verdict, jurors must agree that the defendant is guilty beyond a reasonable doubt. The prosecution has to provide that information and jury has to decide. Depending on the laws involved, the jury may have the option of choosing to convict the accused to a lesser crime. Typically, juries are usually required to reach a unanimous verdict. If they fail to do so, the result is called a hung jury. And in this case, the judge would dismiss the jurors and the prosecutor could decide if they're going to retry the case. If the jury comes back with a guilty charge, the defendant awaits sentencing from the judge. If they claim that the suspect is not guilty, we refer to this as an acquittal. The case is over and the defendant is free to go. Then comes sentencing and appeals if there's a guilty verdict. This is the judge's responsibility to hand down any sentencing. There's two different categories of sentencing. There's indeterminate and determinate sentencing. Indeterminate sentencing means that it's variable. There could be a range from a minimum to a maximum sentence. The determinate sentencing is going to be a very specific amount of time that the criminal must serve in prison. And typically they need to complete their entire sentence rather than a range. This is really all going to be up to individual judges, whether or not they feel that the goal of the sentencing is deterrence, keeping others from committing that crime, whether it's rehabilitating the suspect or it's just incapacitation and punishment. Other sentencing options include a suspended sentence, so later on, a probation, house arrest or home confinement, just a fine, paying restitution, maybe to possible victims or to the state, or a work release program. These are all options that a judge has. And then finally, talking about the correction system, remember when we talk about the Eighth Amendment, if let's say the suspect goes on to corrections, the Eighth Amendment applies. There is protection against cruel and unusual punishment that guarantees that prisoners are provided a basic standard of living. This includes right to due process, equal protection, rights to get mail, to have adequate medical care if needed, and the right to practice religion. The U.S. has the largest prison population in the world, and all of our prisons are very, very different. This is a state-by-state basis. The graphic here kind of tells you some of the crimes that have been committed. The majority of people that were in prison, according to 2016 Department of Justice data, were larceny or theft related crimes. And then again, just a final review of these stages in the criminal justice process. We rushed through it quite a bit, so don't forget to review Chapter 16 if necessary. But basically, we go through these various different stages of the criminal justice process, beginning with a crime and ending with corrections. In the case of some crimes, the stages and the arrest of the investigation and the arrest might be reversed. If you get caught at the scene of the crime, you're going to be arrested before there's an investigation. But not all suspects go through all 7 stages, as we've demonstrated in the explanation of the criminal justice system today. Hope you learned something new about the criminal justice system. Thanks for listening. Bye-bye.